Justice, the appellate division for the department, hear ye, hear ye, hear ye. All persons having business to do before this court will draw near if their attendance shall be heard.
Thank you. Please be seated. First case on for argument today is 277 People versus Johnson. Counsel, can you hear us? We can't hear you. You might be muted.
I apologize for that. Can you hear me now?
No apologies needed. Things happen. I can hear you fine. Please proceed.
Thank you. My name is Kellyanne Argy, and I'm here on behalf of the defendant, Jeffrey Johnson, today. And we would like to argue the question of whether or not when Mr. Johnson was resentenced, immediately following his sentencing, his actual sentencing, whether or not it was a clerical error that the court was correcting in resentencing him, or whether or not Mr. Johnson was actually uninformed about what was going on when he was called back in to be resentenced. And there are multiple reasons for that, because the record is not clear. There is no detail as to why Mr. Johnson is being resentenced by the trial court. The trial court simply says—
Let me interrupt you, okay? So the plea agreement called for the sentence to be 1.5 to 3. Is that right?
the plea agreement did call for 1.5 to 3. That is correct.
Okay, and then the court misstated, the plea agreement in the first instance on the day of sentencing.
In the first instance on the day of sentencing, yes. So I will say that the court said at sentencing 1.5
to 3.
Excuse me, 1.5 to 3rd. She uses different terms, 1.5 to 3rd, and then sentences him to 1.3 to 3.
Right, but in the end, she realizes her mistake, and before the end of that day, resentences him to what the plea agreement actually was.
Correct.
Okay.
However, what we would like to argue is that the trial court during the entire plea agreement used those words interchangeably and also stated to Mr. Johnson on more than one occasion that she hadn't determined what the sentence would be. She did inform him on what the maximum sentence could be, but there was no indication on whether or not she could reduce the sentence and go with minimum. And there is no minimum presented to Mr. Johnson. Whatever it may be is basically what she says during.
So let me ask you this question. I think probably the most important question. Is this error preserved for our review?
We believe it is, yes, Your Honor, as argued in our papers, that there was no need for it because it was not a voluntary, knowing, and intelligent plea.
Okay, so that is normally preserved by a motion to vacate. And I don't see that that was the situation here.
I would rely on points 2 and 3 with respect to preservation, which I would have to refer to my paper because I really didn't focus on that preservation.
You're relying our interests of justice jurisdiction to get there. Is that right?
Yes, Your Honor. Yes, definitely.
All right. I think we.
Anything further, counsel?
I would just like to point the court's direction to also that when he was resentenced, Mr. Johnson, obviously there were some issues going on. He didn't want to come back in, but he states on the record that he was wanting to just speak to his lawyer. And the trial court, there's no indication on the record whether or not the trial court allowed him to do so. And in fact, we find some aggressive statements by the trial court along with the defendant, but we really don't expect that kind of thing from the trial court. I think that it's very clear the lack of communication, the lack of detail, the lack of information being given to Mr. Johnson at that resentencing without him being able to speak to his lawyer is clearly showing that he was uninformed.
Thank you, counsel.
Thank you, Your Honors.
Case 278, People versus Winsett.
Good morning, Your Honors. Sean Hennessy for the appellant, Mr. Jonathan Whitsett. I'm going to focus on 3 points in oral argument. My first being weight and sufficiency, the second being misconduct, the third being the defective grand jury proceeding due to prosecutorial misconduct. As far as point 1 goes, Mr. Whitsett challenges both the weight and the legal sufficiency of this conviction. As Your Honors have read,
This is a circumstantial case.
I mean,
There's no witnesses to the shooting, right? There's no forensics relative to gunpowder on the hand of the defendant.
That's correct.
There's no fingerprint evidence that is damaging. We have a situation, according to your argument, we have a situation where the officers had no one else to point to, so they pointed to him.
That's exactly right, Your Honor. They actually did have someone else they could point to, though, and that was Mr. Ward, but he was never investigated.
Right. Had they investigated him, they would have found out that he had a previous conviction, which the detective that was investigating this case, when he learned of that, kind of said,
waived it.
Not a big deal.
Yes, Your Honor.
Right.
And I'm not saying that Mr. Ward was the shooter. I'm just saying that he offers another alternative to Mr. Whitsett and something that, the people should have looked into, the police should have looked into, but did not.
And part of your argument today is, and I don't want to get you off your points, because you're limiting your argument to the 3 points, and we appreciate that. But really, there's your argument is those points have to be looked at together. And the fact of the matter is, your argument, I think I understand it, is you've got, when you have a case like this in circumstantial evidence, and you've got prosecutorial misconduct, as you allege there was, right? And you have testimony of witnesses that's coming out that shouldn't be in, that maybe if there's one instance, it's okay. Maybe if there's 2 instances, it's okay. But the compilation of the problems in this case, coupled with the fact that it's a circumstantial case, you think the 2 may have bled into each other, causing the jury to come to the verdict it came to.
Of course, Your Honor. The misconduct was pervasive from the beginning to the end. And again, yes, you are correct. This was a very, very limited case as far as the evidence goes. And as the evidence decreases, the lack of prejudice from misconduct increases. And I would, I don't want to deal in speculation here, but even if this was a strong case, the amount of misconduct on this was unreal. I mean, from the beginning to the end. At one point, the prosecutor questioned my client on cross-examination, asking him, "You're testifying because you want to influence the jury."
The judge issued a curative instruction on that. What's your take on
There was no curative instruction. I mean, he said something, the judge said something, but
that? He had the right to testify. Yeah.
but-
and everyone has the right to.
yeah,
That was his.
that was it though, Your Honor. I mean, there needed to be more than just hand waving saying everybody's got the right to testify. I mean, he had to assure the jury and assure the fact that this trial was not going to be defective by telling them this is a constitutional right. This is something that everybody has the right to do, to testify in their own defense. And for the prosecution to just denigrate that and say, well, you're trying to influence the jury in the context of everything else.
So based on what Justice Whalen was saying, is it your opinion that in and of itself is enough to reverse the conviction, or is it the totality of the other prosecutorial misconduct that you're going to be referring to?
I would say that the pervasiveness led to a pattern of misconduct, and I think the court should look at, I think that's the easiest way for reversal for the court to look at, is just the pervasiveness and pattern of the misconduct. But if I were to pick one where it was the killing shot, it would be that. He destroyed any constitutionality that my client had in testifying.
Let me ask you this. And you know the record obviously much better than I do. But one of the difficulties, I'm wondering if you have an answer to this. One of the difficulties, I think, in this case is you have the victim who has a gunshot wound in the passenger side of the car. I think the only testimony was the forensic testimony about the point of entry being, I think, the top right side of the forehead
That's correct.
on a downward trajectory,
That's correct.
right?
Yes.
And there was some testimony about the proximity of the shot, where it was when it was being taken. But assuming for the sake of argument that the prevailing evidence is that it was not a gun pressed to the head, and it was not a gunshot that was very close to the head, it had to be some distance away. When the defendant arrived back to the car from the liquor store, the second liquor store, and saw the victim, what he thought was asleep. I think that's if I have the facts, you'll correct me if I
That's
get
correct.
wrong. And drove off without attempting to wake him up. The window was up in the car. There was no shattered window. There was no, and I can only picture somebody standing outside the vehicle and the gunshot coming through. And so if the window's up, does the shot have to take place inside the vehicle?
It does, unless someone shot him and rolled the window back up, which doesn't seem likely. But if it took place, it would have to have taken place on the driver's side of the vehicle, and the trajectory of the bullet, it doesn't make sense. I mean, I guess conceivably it could hit a downward if his head was turned, but even then, it doesn't seem
There's
likely.
no indication of a ricochet inside the
No.
inside the vehicle. I guess there's the victim could have possibly turned completely to the left
Yes.
to expose that part of his head. But I'm confused and I'm troubled by how does this happen? But this gets back to my initial comments that your argument is, yes, it's difficult to explain how this happened. But because they can't explain how this happened doesn't mean that the defendant did it by default.
That's 100% correct, Your Honor. There's inferences and there's evidence. I mean, there's an inference of suspicion. Sure. I mean, Mr. Cobb was found in Mr. Witzeth's vehicle.
Mhm.
There's a couple things that point to suspicion, but suspicion is not proof. And there is no proof here at all. I mean, there is no, I mean, as we've already talked about, I mean, there's no forensic testimony, there's no forensic evidence, there's no witnesses, there's no surveillance footage.
There's no
nothing.
history of the defendant ever operating a gun.
No, I don't think he knew how to. From the record, he testified. He's never held a gun in his life. So in order to hold that gun and to go with the theory of how Mr. Cobb was shot, he'd have to be a heck of a marksman from that angle shooting him, so.
And from some distance.
Yes, yeah, because I mean, they eliminated point blank, they eliminated a short shot. It had to be medium or longer, and I think she categorized medium or longer as 10 feet or longer, something like that. I might be misstating the record, I might be wrong in that, but I think that's what she said.
Why don't you get to, because we got a busy calendar today.
Sure.
Why don't you get to the grand jury issue for us, because you did want to touch upon that.
I did, Your Honor. Would you expect an innocent person to tell you that? That was a question that was asked by the prosecutor. Do innocent people give false statements? No. Prosecutor doubles down on that. Who does? Police officer, guilty ones. He engaged in it. Excuse me. And when he didn't engage with it, he stood by idly and let it happen. I mean, and as the prosecutor and the grand jury has a duty to justice and instruct the jury on what is proper and what is not.
How many pages is the grand jury testimony?
It's 120, and there were six pages of
It's
this.
161.
Okay, 161. I mean,
6 pages of this, right?
the last 6 pages, Your Honor.
And there's 12 witnesses.
Last 6 pages, though. That was the last thing they heard.
There's 12 witnesses.
I agree with you, Your Honor, but this was broken up over a series of days.
So it's 2 days, right? But isn't it, what's the overall pattern of bias? The last 6 pages?
Yeah, the last 6
161 pages, you're saying 6 pages is the overall bias?
It's not arithmetic, Your Honor. It's when it took place. It was the last witness. It was the last thing the grand jury heard before they were instructed. You can't unring that bell. I mean, if it was the first witness, I would agree with you and say, well, maybe we don't have much of a case here. But it was the last things that the grand jury heard before they voted. And I think that has to count for something other than just 6 pages.
And part of your argument, I think, if I understand the grand jury, is that once this was done, there's an opportunity for the prosecutor to fix this by charging the grand jury,
Of course.
by explaining to the grand jury what their duty is, what their responsibility is, what they should listen to, what they shouldn't listen to, what was wrongly put before them, what wasn't.
Yes.
And part of your argument is that didn't happen.
It didn't happen. And part of my argument too is it should have happened as it happened. And he should have stopped the police officer and gave a curative to the grand jury at that point. He did not. In fact, he suborned it. I mean, he asked for it and he engaged in it. I mean, at one point, I think it was Detective Constantino characterized the right to silence and the right to counsel as obstruction of justice. How do you get around that, Your Honor? I mean, even if it is the last 6 pages, again, it's the last thing that the grand jury heard. And for them to hear that, well, you know what, if you ask for a lawyer, you remain silent, you must be guilty and you're obstructing the police officer. Without instruction, without more, that's what they voted on. It's one piece of the puzzle in an intricate tapestry of misconduct that began at the grand jury and ended at closing argument.
But for that testimony, those last 6 pages, the grand jury would not have indicted?
I don't think they would have. I think that the evidence was the same evidence as the trial evidence. It was still scant. It was still speculative. It was still circumstantial. There's no reason to believe they would have if they didn't hear that. If the police and the prosecutor didn't denigrate my client and his constitutional rights, there's a chance, and that's all there is. That's all there is necessary. Is if there's a chance that they would have voted differently.
Just to follow up on Justice Montour's question, wasn't there 10 other witnesses that testified?
There was, Your Honor. But again, I would state that this was the last thing the grand jury heard. Was this witness, this testimony. With 12 witnesses and 160 pages, I'm sure a lot of it was forgotten. But that was the last bell they heard rung before they were charged and they voted. So I would say that again, we don't look at arithmetic, we don't look at the amount, we look at pervasiveness.
Willful and pervasive.
Yes.
And it was 12 witnesses and 10 testified before those last 2.
One comment, though, Your Honor, could be willful and pervasive. One comment, and this was more than one comment. And again, it's not how many witnesses and how many instances there were. It was the effect of it and how damaging it was.
One of your arguments, I think, is in terms of willfulness, is that you have the prosecutor asking the leading question and drawing out the improper answers from the detective and the grand jury.
That is correct, Your Honor.
I mean, it's not, which we sometimes have, where you have lawyers trying cases or grand jury presentations where they ask innocent questions and the witness just kind of out of left field throws out a problem answer.
Sure.
And then that has to be fixed. But here, I think your argument is there was willful conduct here in that the prosecutor was intentionally eliciting this information. And the person that structured the witnesses and left this witness to the very end and left this questioning to the very end was the prosecutor, right?
That is correct, Your Honor. He pieced it together and he engaged in it. And again, when he didn't engage in it, he just stood there silently while he let, Detective Constantino talk about it. To me, that's willful and pervasive. It's not the amount of times it happened, it's how damaging it was.
Any further, counsel?
No, unless the panel has any other questions.
Thank you.
Thank you.
May it please the court, Michael Hillary for the people. If I may, I'll begin with the last point first, the grand jury. Justice Montour, you pointed out correctly on this record that we had a 161-page transcript. There were 12 witnesses, as Judge Hanna, you pointed out. Typically, when we're looking at grand jury proceedings and we're deciding whether or not they were problematic and they should result in dismissal, we look to see if there is pervasive misconduct. and typically willful misconduct. I don't think we get there on this record. 6 pages of suspect questions, 6 pages out of a 161-page transcript. A prosecutor might go into the grand jury and he might just have a bad day. And the reality is, when a prosecutor has a bad day at the grand jury and makes some mistakes, he doesn't have the benefit of a judge and he doesn't have the benefit of a defense counsel raising objections to correct the situation. He is there himself as judge and counsel. Maybe the prosecutor had a bad day, but this was not willful and it was not pervasive. And I think the record attests to that fact. Moving on to this. I'm sorry, I thought Your Honor had a question.
No, I was just looking at some of the testimony from the other witnesses as far as being, the compilation videos and certain things that happen and throughout. It appears as though, the grand jury members could have, obviously recalled all that information and possibly put aside the comments by Constantino with respect to these other various items. Because it appears as though there's a significant amount of evidence here that the grand jury could have considered to indict.
I believe that's correct, Your Honor. And of course, there is a lesser standard of proof at the grand jury than the trial. The trial jury convicted. It was proof beyond a reasonable doubt. And here they had reasonable cause to believe that the defendant committed the crime. So much the same evidence, that's correct. And I think with a lower standard, there's no issue here.
Counsel, just so I'm clear about your argument, is your argument that at the very end of the grand jury proceeding, when the questioning is being elicited from Detective Constantino, I believe it's Detective Constantino.
Yes.
Yeah. When that questioning and answer takes place towards the very end of the presentation, before the grand jury is about to either return a true bill or a no bill, right?
Yes.
And there's no charge to correct the problem. But before we get to that, do you agree that there's a problem with the question and the answering that's taking place just before the grand jury begins to deliberate on this?
Well, I definitely think the prosecutor would like those questions back. Yes, I think that was a problem. My only maybe disagreement with counsel here is that when a grand jury presentment results in dismissal, it is under case law because they cannot be relied upon. Those proceedings can simply not be relied upon for a reasonable result. And it looks to misconduct being pervasive and willful, an overall pattern of bias here. And I just don't think we get there, Your Honor, with 6 pages of last.
So if, and I'm not saying this happened, I want to be very clear about that. But if this grand jury presentation was set up deliberately to arrange for all of the witnesses that came in the order they came in, and Detective Constantino was positioned at the very end intentionally with the questioning, which was being asked of him, and the answers drawn out. If that was the design of the presentation of the grand jury, written down, structured, would you say that that was willful and pervasive?
If the prosecutor intended to elicit those or ask those questions, improper questions, and set it up that way, then I think you certainly have a willful attempt there or intention by the prosecutor.
Does that pervade the entire presentation? Because it was set up in a way that was designed in a way in a case where a prosecutor knows that this is a circumstantial case anyway. They have no witnesses. They have no DNA. They went and searched the cameras in the community to see what they could find. They've got nothing, right? They've got no gunpowder residue on the defendant's hands. So if this was set up in such a way, and I'm not saying it was, but I want to know what your answer is to this. Isn't that pervasive? Doesn't that pervade the entire presentation? When we talk about pervasive, we're not talking about, well, if everything was fine up until the last 6 pages, then it's fine. Pervasive is, does what happened infect the entire presentation?
I agree with Your Honor. And I think my statements to the court on the issue imply that such a design did not exist. I don't think this was a nefarious presentation. I don't think the prosecutor woke up and said, I'm going to orchestrate this. I'm going to arrange it so that the concluding remarks are going to be improper and it's going to taint the jury. I just don't believe that for a second. I don't think there's any evidence of that.
I want to go back to your statement that the prosecutor was having a bad day. And I think you could have a bad day with the wrong question slipped out of your mouth, not the way you wanted it, but this was a series of improper questions, one after the other. It seems to me quite a bit more than a bad day.
Well, Your Honor, there was, to be clear, in the record, there was a remark by Detective Costantino, which is one of the remarks that counsel is pointing out was improper to the grand jury, that was not elicited by the prosecutor. It was actually non-responsive to the question. Not all of what came out was directly elicited by the prosecutor. There were certain questions that were improper. For example, would you expect an innocent person to do that or say that? Or who typically makes false statements? I think it was a question to that effect. That was improper. There's no question about it. But I don't think, Your Honor, still that this is a highly circumstantial, it's an exclusively circumstantial case. And the grand jury is hearing speculation of a silent shooting, which is going to be almost impossible for the people in these circumstances to falsify. It doesn't matter what proof the people put on. If someone gets it in their head that this was a silent shooting, there really is no chance out of the gate for the people to prove their case. So now that doesn't justify asking improper questions, but I think we can maybe sympathize with the prosecutor here who believes that this defendant is guilty of a crime here and is trying to present the case in the best possible way. Maybe a little latitude is in order. I believe that it was a bad day for the prosecutor in the sense that he clearly, in retrospect, would not have asked those questions. He did. But I don't think the record as a whole, and I don't think the record proves differently, the record as a whole doesn't show that this was intentional by design, pervasive. It was an overall pattern of bias. I just don't see it.
Even so, it was, in the sense that it's got 161 pages, you got 12 witnesses, Constantino's the last one. It has to be typically willful act on behalf of the prosecutor. Is this deemed to be, could it be considered to be an isolated incident, such as in the Houston case has indicated that isolated instances of misconduct do not invalidate the grand jury proceeding?
That's right, Your Honor. That's right. And I think that's really what happened here. I think the prosecutor would say that he had a bad day. Again, it doesn't justify intentional misconduct. I just don't think that's what's going on here.
That's not in the record about a bad day.
Right.
I mean,
No,
that's-
no, Judge, it's not.
Then we can say, well, how experienced is this prosecutor? Is he a rookie? Is he someone that, because if we knew if he was there 30 years, we say, well, it's probably not a bad day. It probably was intentional. And if he's a rookie, you probably say he's inexperienced. This bad day thing is kind of.
It's fair enough, Judge, but he's a colleague of mine, but it happens, Judge, that that you don't have the benefit. This is.
He's a colleague here. You don't have to tell me how experienced he is.
The prosecutor before the grand jury just doesn't have the benefit of the insulation offered by a defense attorney and a judge. And so when a prosecutor makes a mistake at the grand jury, it's magnified, right? There's no correction, there's no argument, there's nothing. It's just the prosecutor and it's a mistake. And it's very easy, maybe with a couple of mistakes, maybe several, to look at that prosecutor with some skepticism and say, what gives? And my only suggestion to this court is I think looking at the record as a whole, this prosecutor was not trying to tarnish the proceedings. It wasn't his object, however mistaken some of those questions were.
Your opponent might want to argue that at the end of the vote of the grand jury, it was the defendant that had the bad day here. But do you want to move on to the other argument?
Sure, Your Honor. I'll go to sufficiency if that's what the court would like. Yes, this was a circumstantial case, but this defendant was alone with this victim the entire night. And there is no evidence that anybody else was in the defendant's black sedan but William Cobb. These two, for several hours, from the time they left the comedy club to the time they roll up to or near William Cobb's house, the defendant had opportunity. There is absolutely no evidence to suggest that anybody else committed this crime. None.
What about Mr. Ward? I mean, there was a
Yes,
contention
Your Honor.
by your opponent indicating that all the police didn't investigate Ward.
The only thing about Ward is speculation. That the fact that they may have been involved in some kind of relationship and the fact that Ward may have known that the defendant, well, actually, he would have known according to the testimony because the William Cobb introduced defendant as his boyfriend, is speculation that somehow Ward now has it in for Cobb. That's it. It's
And
just,
where was Ward's opportunity? It seemed like the only time that they weren't together, Cobb and the defendant, was when the defendant was in the liquor store.
there's testimony that Ward lived about 20 minutes or so from Cobb's house, but there's no testimony that he actually ever showed up. And there's certainly no testimony that between the time they leave the comedy club to the time that they get to Cobb's house, that Ward has any interaction. He's not present. He's nowhere to be seen.
He's on the phone with
I think that's pretty clear, right? There's no testimony about any of that.
Right.
I think your opponent's argument might be, there was no investigation either. There was no effort to try and investigate Ward, to find out where he was, to get his cell phone information, to track down where that phone was moving, which we do all the time in these cases. Now that we have this technology, right? So there was no effort. So to say that there's no investigation and that he was dismissed as a potential suspect, and then say because there's no evidence, it's all speculation, seems to me to be, begging the argument.
Judge, I'd respectfully differ with Your Honor on the point that there was no investigation because Detective Costantino did question Ward. He did speak to Ward about it, and he concluded from that discussion that Ward was not involved.
He asked for Ward's phone.
I'm sorry.
He asked for Ward's phone, and Ward said no.
That's true.
He
And
never did a background check on Ward to find out that he had a criminal conviction for, I think, some kind of assault with a weapon.
he did. He did have that. I think
He never even did that
several 10 years
research.
prior, I believe it was, but I'm not sure.
Had he done that initial step, might he have taken more of an investigative interest in Ward and
I think
attempted to get the cell phone records, attempted to do more, attempted to find out where he was, talk to the people that he was with to confirm his story?
all of these things could have happened, and we would all say at the end of it, that's fantastic, that's great. I don't think the fact that they didn't do all those things renders this investigation completely flawed and unreliable because you had other witnesses like Jessica Rivera, Cobb's friend. You had the testimony from the defendant himself. Ward is not around. He speaks about who was at this club, who was present. You had Cobb, you had Rivera, you had the defendant.
He said Ward is not around where?
Anywhere at the comedy club. There's no testimony that Ward is present at the club
But that's
or when they leave.
That's my point. My point is there's no testimony as to where Ward was. So your argument is Ward wasn't anywhere. Ward wasn't there. We don't know that because there was no investigation into Ward. You're saying because there was no testimony about where Ward was, he wasn't there. You see the flaw in the argument?
I think Your Honor is saying I'm begging the question, and I understand Your Honor's point. I would just say that it's not without value that no witness ever points to Ward being there, right? So it's speculation to say that Ward may have been there if no witness is saying that he was there.
It's one of the problems, I think, with investigations where the investigator jumps to an early conclusion, comes to a resolution as to who they think did it. They're sold on it, and they close off all other avenues and don't go down those just to check them off to make sure due diligence was done. And in this case, had there been some steps, I think your opponent would argue, some steps, Ward would have been further investigated. And then we would know where Ward was. And maybe your argument is an investigation was done. Ward wasn't there. He was over here. And we know that because he had his phone and he was texting and the phone was bouncing off a cell tower, 50 miles away. We don't know.
And I want to, just for sake of argument, I want to adopt everything Your Honor just said, that this investigation was flawed, that it didn't go as far as it could have. But I'd like the court to consider, yes, it's a circumstantial case, but consider all of the circumstantial proof. Consider the defendant's own statements to Detective Stephanie. There's 2 interviews. Consider, as Your Honor already pointed out, the fact that there is no bullet damage to the body of the car, none of the door panels, no bullet damage to the windows. consider the fact that between 11:36 PM on June 18th and 11:38 PM, defendant's vehicle comes to a stop. It's a 2-minute stop shortly before reaching Cobbs's house, where you would have had opportunity. Consider the fact that the defendant had no answers for anybody. From the time that he's speaking to Cobbs's mother on the phone, and she is saying, you were with him the whole night, what happened? You had to have seen something, and he just doesn't have anything. Consider the fact that his story changed when talking with Detective Stephanie. First, he didn't mention that there was any phone call between Cobb and Ward that happened in the defendant's presence in the car. In the second conversation, suddenly Cobb is having a conversation with someone. He doesn't name who that person is, but someone. And we know from talking from the rest of the proof that, and from the messages that are on Cobb's phone, that there was some romantic dialogue going on between Cobb and Ward. And we know that there was trouble in this relationship between the defendant and Cobb. There was professions of love at one point, and then there was abuse going on at the other point. And we know on June 4th, Cobb said to the defendant, congratulations, you're single, right? So defendant lied about the fact that there were problems, even abuse in his relationship with Cobb to the police. The defendant also admitted that Cobb was probably speaking after he returned from the second liquor store to get to that car and go to Cobb's house. So Cobb is still alive, according to the defendant, and what the defendant probably believes was going on. So now you've got the drive from the second liquor store to Cobb's house and the 2-minute pause. And the defendant only discovers at the house that Cobb has a bullet hole in his head and can't explain this. It's maybe a negative proof case, but who else if not the defendant? I mean, who was with him the entire time? There was no evidence in this investigation that anybody but the defendant was with Cobb that entire night. So, unless the court has any other questions, I'll wrap.
Counsel, thank you for your argument.
Thank you very much.
You're going to call this one?
Okay, case number 279, the People versus the Quinn Gray. Morning, counsel.
Morning.
You can proceed.
May it please the court, Nicholas Tafonso for Dyquin Gray. I'll be addressing points 1, 2, and 3, but from the outset, I'd just like to note that these points are interrelated and the prejudicial impact in each needs to be considered in the context of the whole, really. So the overarching argument here is that this was a weak case where the deficiencies in the proof were filled in with highly prejudicial and improper testimony and prosecutorial misconduct. Point 1 is that the verdict is against the weight of the evidence. The verdict hinged on the testimony of 2 witnesses who were problematic. They were both, for one, biased. Bell had an agreement with the prosecution and reduced his sentence from a life sentence down to between 5 and 10 years.
And the jury heard that, right?
The jury did hear that,
The
yes.
jury knew of it and they could assess whatever they wished to that testimony based on this deal.
Yes, the deal was not hidden from the jury. They were aware of that, but there were also, I mean, there was more than that, more problems with Bell's testimony than just that it has that inherent motive there. But the testimony itself, as I argued in my brief, manifestly appears tailored to distance himself from the event, from the crime itself. There's multiple things.
Well, first he denied any involvement, whether he was even there, correct? That's your reason, that's your main point for why the verdict's against the weight of the evidence.
Well, are you referring to his initial denial to the detective that he was there?
Yeah.
I don't think that's my main point. I think that
Key point.
it's a key point, sure. I think there's just a number of his final story that he settled on at trial is not believable in several respects. One of them is that He says that the shooter was masked the entire time, and that he was picked up on the side of the road. He's masked on the side of the road, and then they drive around for something like 45 minutes to an hour, and then he's masked the entire time in the car. That doesn't seem likely, just to me. Then it was only on cross-examination where he's questioned about how he knew who the shooter was if he was masked the entire time, and then he volunteers that, oh yeah, Coleman, who's now deceased, called him by his nickname. But that was only on cross where he says this. Then there was the idea that he was selling rides, and that was the reason why the shooter was in his car in the first place, but they had never agreed on a price, right? So that doesn't make any sense. And then his story is further contradicted by the video evidence of the car, right? So the video compilation shows the car essentially acting as a getaway car, right? He's not just waiting for him to get back from the gas station. He's making a K-turn, the door is opening as the guy is running to the car, and the car is already taking off before the door is even closed, right? That's all on video, and it contradicts his stance here, and it supports what I'm saying, which is that he was testifying to distance himself to the furthest extent possible.
What you're pointing out here, didn't defense counsel point that out at trial?
Yes.
So the jury was aware of these arguments.
Yes, the jury was not unaware of these arguments. Yes, right. There was another witness who also was biased. She has her. I mean, to summarize this as complicated and significant domestic resentments, say, and.
And
You may say, but I'm sorry. You may say bias. Maybe this is someone that was along for a ride they didn't want to be on anymore, you know?
Oh, I'm talking about McGee Thomas. Are you?
No, you're saying the witness may be biased, but unless I'm confusing the facts, isn't this where someone was seen going into a liquor store? And then next, they kept watching and following the individual. And then he told the car to pull over here while he ran over to the guy at the gas station.
Well, I'm saying that the witness Bell and witness McGee Thomas were biased for different reasons. Bell is biased because he doesn't want to be.
No, but you're saying biased. I'm just trying to keep an open mind.
Sure.
But it could be three people in a car and something happened that they weren't with anymore, you know? So they went and gave testimony to the district attorney's office or to the police.
Sure, but that isn't what appears to have happened. What appears to have happened is that Bell was very much involved as a getaway driver in this incident. He doesn't appear to be someone who's just a hapless Uber driver who finds himself.
He knew these
participating in a
people
crime.
ahead of time. It wasn't a random, drive for hire situation. They knew each other.
Yes.
Okay.
Although he didn't want to admit that at trial, he kept saying that he knew of this person and refused to really say that he knew them, even though McGee Thomas then, and this is where I sort of differ with the prosecution on this point. My point here about McGee Thomas, her testimony here conflicting with the video evidence, she says that there was a meeting beforehand between this group of people, which also conflicts with what Bell said, but that they were discussing Robinson basically as a target for a robbery. But then the video shows Bell arrived with his car at the liquor store first. Then the target arrives and parks behind Bell and then walks into the store. Bell then leaves his car and walks into the store. So the idea, I've described this in my brief as them being improbably lucky, right? It doesn't really, like, how could they have been discussing him as a target beforehand and then have him, this target, just arrive after they're already at the liquor store? That goes against the theory of the crime in the opening statement as well, which was that this was more of like a crime of opportunity, that this guy was noticed at the liquor store, and that's why they followed him to the gas station. That conflicts with what McGee Thomas is saying here, which is that he was the target the entire time.
So
And,
I guess I'm going to ask you the same question that we've all asked you. I mean, none of this, we all know all this because it happened in front of the jury. It's part of the transcript. The jury got a chance to evaluate all of this conflicting information or improper motives for their testimony. And we come out with this, but we need to, evaluate the weight of the evidence and the sufficiency of the evidence, and we will do that.
Yes, I think that this case very well could have led to an acquittal were it not for the other errors that are presented in points 2 and 3. The first of which was McGee Thomas's testimony that this wasn't the first time that Mr. Gray had told her that he had shot someone.
Right, so let's talk about this. So didn't the judge give a curative, there was an objection right away, correct? And
there was an objection right away, but the judge's instruction was, I described it as mild, right? First he said he didn't hear it. And then he said, well, since it's by consent, disregard it, as though that was the only reason to disregard it, because
that's what for previous counsels have said about a judge giving a mild almost be mild curative instructions in Erie County.
It was the same judge.
Oh, yeah.
Yes, I think that it's pretty clear that everyone was able to, but the judge was able to hear the comment. There's no indication in the record that besides the judge not being able to hear it, that anyone wasn't able to hear it. The judge is the person closest to the witness. But that comment was highly prejudicial, right? I tried to make a point of that in the brief with a footnote saying, forget you ever heard about this comment. But once you, I mean, this is a cliche now, but you can't unring the bell, right? You've heard now this accusation that this guy is some maniac, loose cannon. You can't forget it. And the argument here ultimately is that it was just so prejudicial. There's no legitimate strategy to be had by not moving for a mistrial. But the prejudice here is compounded with the process. Oh, go ahead.
If there was a curative instruction, is asking for a mistrial, is that something that is a futile act, considering that the court did give what it considered to be a curative instruction here?
Well, some testimony is too prejudicial for curative instruction to cure.
And you believe that was here?
Yes.
Okay.
That's our argument. Yes. But it's all compounded by the prosecutorial misconduct throughout the trial. I think I identified 6 categories of prosecutorial misconduct, but I'd just like to highlight a few. One that is vouching for the witnesses here, right? So the prosecutor says, we have taken great care to make sure that the evidence that we've presented to you is credible, reliable, and ethically obtained. Well, great. If I'm the jury, I'm saying, well, thank goodness I don't have to worry about any of these problems identified to me before with these 2 witnesses here, upon which the whole case hinges. This is improper. This is misconduct. It's vouching. It's injecting the credibility of the DA's office into the case. And another highlight here is character assassination. Okay, so I tried to make this as clear as I could in the brief, but the focus here is this narrative logic throughout the trial that Mr. Gray is this villainous character who needs to be stopped, right? You jury are the only ones who can do this, as opposed to jury. This is a fact-finding proceeding. Here's the evidence. Find some facts, and we'll take it from there. So it's the difference between fact-finding and this sort of, like, for lack of a better phrase, a witch hunt, right? This is sort of like it's character assassination in the case law and misconduct. Unless the court has any further questions.
No, counsel, thank you.
Morning, Your Honors. May it please the court. Maggie Van Lupen for the people. As we haven't been very brief this morning, I'll try to be a little bit more brief, because I know we have a lot to get to. But I do want to make some salient points that I think are touched in my brief, but just to make them a little bit more clear. Your Honor, what we have here is 4 people in a car. One of them is deceased at the time of trial and grand jury. 2 of them testify. The third is the defendant, right? So when we say we have no eyewitnesses to the incident, what does that really mean? No one person can identify the defendant is the shooter, right? However, with all of this evidence combined, there was an eyewitness that said the shooter got into this car, right? There's no question about that. There's no, nobody said at any given time, the shooter did not get into this car and out of this car, right? So we know it's one of 4 people, right? And we've whittled that down very easily with an abundance of evidence. We have video from the liquor store that shows the 4 individuals in the car. We have Corey Bell, who's undoubtedly the driver. No one said this isn't Corey Bell's car or he drives it. No one said he's not the driver, right? And we've ruled out Corey Bell as the shooter because he's the driver. He is the one that's got the car running. That's like, you know, somebody's throwing the door open in the back. We've got him as a driver.
He was the getaway driver, according to your point.
Exactly. So how could he be the shooter? He can't be, right? So someone else has to be the shooter. So whatever Corey Bell's motive to tell the story he tell at trial, what does that have to do with whether the defendant is actually the shooter or not, right? Maybe he does want to minimize his activities here, right? So let's just theorize for a moment. What if they all got together, as Miss McGee Thomas says, and says, oh, I want to go get a lick. I know somebody who's got a lot of money. They just came into it, so on and so forth, right? And they're lucky enough to run into the liquor store. The shooting does not occur at the liquor store, importantly. It occurs several blocks away, if anybody knows the topography of Buffalo, at Delavan and Grider at a gas station, right? Do we think they accidentally showed up at the gas station after they were just at the liquor store? I don't think so, right? The testimony is consistent throughout about the main pieces of information. How they got there, why, okay, there's some differences there. But what doesn't differ is everybody saying the defendant is the shooter. He's the one that robbed this poor victim of his chains and his money in cold blood while this guy was trying to run into the store just pumping his gas on an April day. Why does
AJ told them to go park at McDonald's while he ran over there.
Yeah, allegedly, right? But like, do we believe that this person who has a ski mask on April 24th on a sunny day, I believe it was around noon time, do we think that he's up to skiing in April at Delavan and Grider? It's not logical, right? The people didn't have to prove why this happened. They didn't have to prove the knowledge of the other people in the car or what they did and did not know. Corey Bell had already pleaded guilty at this time. He was dead to rights on being the getaway driver. We knew he was in the car. We have video footage of the car. We knew he was driving, right? What we didn't have to prove was that he knew anything else about the robbery. He's already pleaded guilty. I don't think, as anyone here can expect, that he wants to be a snitch. Is that a good situation for anyone? Probably not. I think
the
that
record reflects that he worried about that.
he absolutely worried about it. Not only at trial was that testimony given, he was given that statement at the very first that he paused when he saw Day or the defendant's actual identification, right? So we've got Corey Bell saying this defendant, whether how reticent he is or not, he is Day. He's the person in the back of my car. He's the one in the ski mask. They identified him with an O or a zero-shaped tattoo around his neck, dreads on his neck. At trial, there was a discussion about what his body build looked like, and it was the same at that point in time. There was some discussion about the defendant gaining weight later on at trial that matched the person who ran up and shot the victim in this case. With regards to that, anybody can have dreads, right? That's something. Anybody can have a ski mask, or anybody can go get a ski mask. Do we have one on in April? There was a ski mask that was found in the defendant's home and residence at that point of time.
Let me ask you some questions. Okay, counsel for the defense raised a couple of questions that I thought were somewhat important, including the fact that he claims that the prosecutor, improperly bolstered the office of the prosecution and and proclaimed their ethicalness with regard to gathering evidence and pointing the finger at this defendant.
Your
What
Honor,
about that, please?
that was in direct response to, I believe, this exact paragraph from the defense counsel. Our justice system is deeply concerned that no person who is innocent of a crime be convicted. How often do we pick up the paper and see through the efforts of some very diligent lawyers, somebody who served 10, 12, 15 years in jail for a crime they did not commit is finally released because it was shown they were convicted on either false testimony, somebody recanted their testimony, they said, no, I testified wrong, and this is why, or police misconduct. People are released, not every day, but many times during the year, all over this country because this happens. So the justice system is truly deeply concerned that no person who is innocent of the crime be committed. That is directly attacking not only Corey Bell's testimony, but also everything within the prosecutor and actually the entire justice system, right? We all know mistakes occur. We all know things happen, but this is attacking, they're saying, this is really prevalent. This happens all the time. Several times a day, we're hearing about people falsely convicted. So he's setting up this thing that says, this is not credible. But not in a way that he's saying, oh, the witnesses are not credible. They're saying the entire justice system is flawed. So that was a direct and fair comment we would suggest with regards to what defense counsel is saying. And that was one of several comments. And I would just want to very briefly, regarding Corey Bell, isn't it troubling, isn't it, that our system does that, allows somebody to plead guilty to a lesser offense than he's charged with, or with lesser offense and indictment? He's been charged with robbery. So he's not just saying, hey, this witness has a bias because he's trying to minimize his conduct. He's saying he's absolutely lying about everything coming out of his mouth because he got a plea deal. And look who allowed him to get that plea deal. And this isn't fair and is not fair to my client. And I would say that that was not fair comment with regards to this trial. And the prosecutor's trying to walk back and say, wait a minute, the justice system is not all unfair. We're here to get the right answer, whatever that answer may be, and here's the evidence that we're presenting.
What about the claim that the court's curative instruction was weak and ineffectual?
Okay, so I want to go back to that point for one moment. First of all, we're not even sure that the jury did hear that. And the reason I say that is because this attorney, Mr. Terranova, is an extremely experienced attorney. He's done several hundred trials. Everybody knows Mr. Terranova's name, okay? He's done a ton of murder trials. I think the very innocent explanation is he either said, wait, I heard it, she was speaking really softly, but of course I'm intently listening, I'm the attorney. The prosecutor's intently listening, he's the one questioning, right? But the jury, who is a little further away, may not have heard the witness. The judge, yes, who was older, which my co-counsel mentioned, that justice is not known for not hearing either, even at that point in time. So the logical explanation, the strategic explanation here is they may not have heard it. I don't want it repeated. I don't want this to be a point of contention here. And that is a strategic, legitimate reason for not asking for more than what was already given, right? Let's not call attention to this any further. Yes, it was absolutely awful. No, it should not have been said. But even that's why the prosecutor was like, whoa, yeah, well, whatever you want. we'll do whatever you want. We'll agree with whatever you want. And the judge says, okay, I have his exact words because I think there was some confusion about what those were earlier. He's saying here, she says what she says, which we absolutely agree is atrocious. Terranova immediately objects. The ADA immediately says, I would agree. I would agree with an instruction to the jury to disregard that last part. The judge says, I'm sorry, I didn't hear it. You've got to talk clearer. Sentence suspended by consent. Hopefully some of you didn't hear it. If you did, disregard it. And then the ADA goes further and says, Mr. Terranova, if you want an instruction, I would agree with that as well. And Mr. Terranova just says, I think we just got it. The court says, I tried to do it. Disregard that last comment. And please, you've got to talk louder in the mic, please, okay? So I think there's indications by the judge who's sitting next to the witness that it wasn't heard by the jury. So that's one real possibility. We don't know because the jury's not polled, right? But again, there's a strategic, legitimate example of that. And again, the judge, regardless, makes a curative instruction. And we can't forget at the end of the day, too, what the instructions were at the end that the judge goes through a litany of things about what they should and shouldn't say. If something was told to be disregarded, that you not consider that in your.
I think your stronger argument just it wasn't preserved.
Well, it's absolutely not preserved.
So
But additionally, my co-counsel.
a lot of speculate. You're asking us to speculate. You know, all this. I understand it did say on the record. The judge said, I don't know if it heard you, but you know whether this judge is these hard of hearing. The guy's 35 year. You know, that's all speculation, isn't it?
Yeah, absolutely. I mean, it's speculation.
It's to the side case, not speculation.
Surely not. Perhaps maybe a 440 would be better apt for this for that particular reason that it wasn't heard. It's not on the record as well. I think though that Mark was isolated, there was a lengthy trial, there was many witnesses, there was the prompt instruction from the court, and the trial counsel clearly zealously represented their client. I would say one more thing with regards to that in this particular situation, another strategic analysis would be that even if they did hear it, well, of course, she's spiteful. She's just going to say anything, right? That was his MO in crossing this defendant. Terranova was saying, oh, well, didn't you threaten to kill yourself if he wouldn't get back together with you? I mean, he brought that out, right? So that's another strategic, legitimate reason why they wouldn't. And of course, besides the most important part that is not preserved and it's speculative, would be that even a motion for a mistrial would probably not likely have been granted. And of course, we can't Monday morning quarterback a attorney on that basis. Lastly, Your Honor, I would just state that with regards to point 3, the people did not commit prosecutorial misconduct. And the trial counsel's alleged failure to object did not deprive them of effective assistance of counsel. Again, all of those objections are not preserved. They're also without merit. And the people's comments with regards to the defendant being unemployed or greedy went directly to motive to steal and did not amount to misconduct. And with all of the defense counsel's zealous representations of his client, we would say the prosecutor's comments are fair response. If there are no further questions, the people would rest on their papers.
Thank you very much, counsel.
Thank you, Your Honor.
Okay, case number 280 in the matter of Phillips M.
Okay, counsel, can everybody hear us?
Yes.
Okay, do I have 3 yeses? Yes?
Yes.
Okay, very good. Counsel, please proceed.
Your Honor, thank you. Your Honors, may I please the court, on behalf of Mr. Murphy, our case starts and really ends with that there was no personal jurisdiction ever obtained over Mr. Murphy in this petition, the neglect petition against him. Firstly, substitute service was improperly granted by the court. The Department of Social Services made 3 attempts to serve personally Mr. Murphy. The affidavit referenced someone on the street saying Mr. Murphy is no longer here. There were no further attempts under the Family Court Act or the CPLR 3085 for the department to show that they did investigatory searches for him, any checks in his state, he's out of state, any employment requests, any Department of Social Services surveys before they asked for substituted service. Even though then the court, Judge Filbert at Family Court, determined that substituted service would be an option and was appropriate to her, her order was very specific: nail and mail and email. The affidavit of service that the Department of Social Services then presented to the court and as part of the record only shows email. They did not show nail and mail. They had no proof of receipt of sending a letter. They have no affidavit of service saying that nail and mail was done. Even if the Department of Social Services believed he did not live at that residence, there's no proof of that. No mail was returned to the court. It was his address throughout the case. In fact, it's still his address. And they did not properly conform to the rules under case law for email service. The department and the attorney for the child are correct. Email service is allowable. It's not articulated in the CPLR as an alternate service, but there's discretion to the courts and it's become somewhat commonplace. But because it's not articulated in the CPLR, we need to look to case law. And Snyder versus Alternate Energy states that email service has to be done 2 days in a row and have specific subject lines with the email that follows. The affidavit of service here, again, was only one email, does not have that subject line, and does not have the nail and mail requirements that Judge Filbert articulated all needed to be done, not one. So here, substitute service was first improperly authorized, but once authorized, it was improperly executed, more importantly, and personal jurisdiction therefore was never obtained. Mr. Murphy also never consented to jurisdiction by appearing. At every single appearance, even to this day, he opposes the jurisdiction of the court. He has never participated fully in terms of any asking for any affirmative actions from the court aside from these motions. He's never filed an answer. He's never argued the merits of the case up to this point of this appeal. So no general appearance has occurred. Furthermore, it has to be distinguished. Both the attorney for the child and the department mentioned that Mr. Murphy has conferred his jurisdiction because during the pendency of this action, an order of affiliation was consented to. That is a discrete issue, a limited appearance. There are different standards of jurisdiction. In an Article 5 paternity case, it is where the child is born, where the child resides, or if there's consent. Here he did consent that he's dad, an order of affiliation was ordered. In Article 10, jurisdiction is only conferred by waiver, which he's never done, or by proper service, which we are arguing here was never effectuated. Our second argument lies in that the neglect petition was and is facially insufficient. There was no allegation in the actual petition of actual or imminent harm to the child. While there was no specific acts, no dates, no police report references, no factual allegations that connected Mr. Murphy's conduct to harm or risk to the infant. Sure, it mentions domestic violence, but that was based solely on the mother's statements that were given through a shelter, not even her own statements, with no corroboration. There was no dates or specificity in the petition, and the child was only a month old. While we recognize domestic violence can have effect on any child of any age, there's nothing here specifically linking those things. Furthermore, and possibly more importantly, the mental health allegations against Mr. Murphy in the petition are vague and unsupported. They speculate that he has an untreated mental health need. No diagnosis, no incidents, no dates, no connection to the child. And under Kelly ECDSS versus Kelly C, which this court heard and which the Court of Appeals upheld, such vague allegations of mental health concerns of a parent regarding an infant are insufficient as a matter of law to confer the possibility of neglect. Based on all of these, we would argue that this petition is facially insufficient. Based on that, as well as the service issues, we are arguing that this petition should be dismissed and the reversal of the order of Judge Filbert of December 23rd of 24 that denied the motion to dismiss the petition be overturned. I do feel I have to raise to the court a more current issue right now.
Counsel, I'm going to interrupt you just for a second to indicate that your time has expired, but I will give you just a few seconds to wrap up.
Sure. I think I've already wrapped up, but I do want to raise to the court. There is this case is continuing in the Erie County Family Court, obviously. There is a UCC JEA hearing pending on May 6th before Judge Filbert. Now, that generally the UCC JEA is not relative to the personal jurisdiction we're talking about here today, but it is relative to the petition itself. And her decisions also could affect some of these decisions. Obviously, your decisions will override any of those in this case, but it is new information that came to light to myself just recently, so I wasn't able to bring that to the court's attention or add to this appeal. But as the court is well aware through the transcripts, Mr. Murphy has raised issues of UCC JEA jurisdiction throughout, which are intertwined with this appeal as well.
Thank you, counsel.
Thank you.
Counsel?
Thank you, and may it please the court, Julie Fillion on behalf of the Erie County Department of Social Services. We are asking this court to affirm the family court judgments. We submit that the Erie County Family Court did properly exercise personal jurisdiction over respondent appellant, and that the neglect petition was facially sufficient. We would reiterate that we believe that the respondent appellant did abandon his personal jurisdiction argument when he did appear for his paternity petition just last year in July. Should the court not find that persuasive, we submit that he actually submitted to personal jurisdiction through his many appearances in May and June of 2024, where not only did he continually object to jurisdiction, but he appeared with counsel, he appeared virtually, he made substantive arguments, he provided a witness at a remand hearing, he cross-examined witnesses. So we would say that that constitutes submitting to personal jurisdiction. His counsel, it should be noted, is in the assigned counsel program. So he sought the assistance of the New York court system via Erie County. Then thirdly, we would argue that if the court doesn't find that second argument persuasive, that we actually did effectuate service over respondent via subservice, substituted service by email, which was directed by the family court judge, which is allowable in the instances when actual personal service would not be practicable. And here, the information that the process server transmitted via the affidavit was that it looked as though this guy was on the run. Someone had informed him that you're not going to find this guy here. He tried 3 times. The affidavit lists 3 different times and days that the personal service was affected. So the law doesn't mandate that you have to keep coming back in the face of information suggesting that someone is dodging service. Significantly, he had a witness testify, his Pennsylvania attorney, that email address was how he communicated with respondent appellant. Notably, he did not ever say that he did not receive the petition and the summons for the neglect proceeding. And his own counsel for the neglect in Erie County said, we were waiting for service. Now that it's been effectuated, we can move on with our objections. So notably, he's never said I didn't receive it. His appearances suggested that he knew what was going on, and we're not charged with giving with actual service. It's the best service to try to give notice, right? What we're talking about here is due process, notice and an opportunity to be heard. And we maintain that respondent appellant had that via all 3 of these methods. As for the petition itself, as the court knows, all of the allegations are to be given liberal construction, and where we prove up those allegations is at a trial, at a fact-finding proceeding. And here, there were several alleged facts that are so concerning. We maintain that if the child's physical, mental, or emotional condition was not impaired, that it was in imminent danger of being impaired. Keeping all of these unregistered firearms at the bedside table